Are you holding off on filing a lawsuit or maybe a family law petition just because you literally cannot afford those steep filing fees? Well, what if I told you there's a built-in mechanism for financial relief right in the Washington state court system? Welcome to our explainer. Today, we're diving into exactly how to apply for a court fee waiver in Washington. It's basically a process that can completely knock down those financial barriers, keeping you from accessing the justice system. Look, navigating the legal system is stressful enough for a beginner, right? You absolutely don't need the added anxiety of overwhelming court costs. Filing fees alone can easily run into the hundreds of dollars, which essentially locks out the people who need help the most. But there is a solution, and it's called General Rule 34, or just GR 34 for short. This rule actually allows courts to waive civil filing fees and surcharges for individuals who are indigent. It's this incredibly powerful tool designed to ensure that a lack of cash never, ever operates as a barrier to justice in Washington state. Okay, let's dive into this. Here is our roadmap for today. First, financial relief for court costs. Second, who qualifies for a waiver. Third, gathering your necessary documents. Fourth, the step-by-step application process. And fifth, after submission and common mistakes. Section 1. Financial relief for court costs. Understanding the scope of GR 34. So if it's granted, a fee waiver is basically your golden ticket for a full year. For 12 whole months, you will not be charged those initial filing fees to start your case or file documents. It even covers the costs for the sheriff to serve your documents, and there's absolutely no charge for available court interpreters. But it is equally important to note what it does not cover. For example, optional services like submitting e-working copies to the court or preparing clerk's papers and exhibits for an appellate court. Yeah, those are generally not waived under this specific rule. Section 2. Who qualifies for a waiver? Demystifying the eligibility criteria. Now, what's really interesting here is that there's this huge myth out there that you have to be completely broke, like zero income, to get a fee waiver. That is simply not true in Washington. Under GR 34, a court actually must find you indigent if your household income falls below 125% of the federal poverty guideline. So to put that into perspective, if you're a household of one and your net monthly income, meaning after taxes and childcare costs, is at or below $1,663, you qualify. For a family of four, that threshold bumps up to $3,438. If you hit those numbers, the court is required to grant your waiver. But what if your income fluctuates, or maybe you just don't have your pay stubs handy? Well, here's a shortcut. If you currently receive benefits from any needs-based, means-tested assistance programs, we're talking things like temporary assistance for needy families, or TANF, supplemental security income, state general assistance, the food stamp program, poverty-related veterans benefits, or Medicaid, you automatically meet the standard for indigency. You don't even have to prove your exact income. Your enrollment in these programs is literally all the proof the court needs. And honestly, here is a really crucial safety net. Even if your income exceeds that 125% threshold we just talked about, you are not entirely out of luck. Courts actually have the discretion to grant waivers to applicants whose net income falls somewhere between 125% and 200% of the poverty guideline. This happens upon a showing of undue hardship. Basically, if your recurring basic living expenses like your housing, food, utilities, and healthcare are so high that you simply cannot afford the filing fees, the judge can still waive your costs. Section 3. Gathering your necessary documents. Building your GR 34 fee waiver packet. Okay, so the very first document you're going to need is Form WPF GR 34.100. It's officially called the Motion and Declaration for Waiver of Civil Fees and Surcharges. Just think of this as your formal request to the court. By signing this document, you are formally swearing, under penalty of perjury, that you are indigent and cannot afford to pay the fees. This is the absolute foundation of your packet. And let's face it, nothing says legal process quite like a stack of intimidating forms you have to swear on, right? But stick with me, we'll get through it. Next up is the financial statement, which is Form 34.0300. This one requires a pretty detailed disclosure of your household size, your employment, monthly income, assets, and debts. It can definitely be a lot of work. But guys, here is an amazing shortcut. If you receive categorical needs-based assistance, like the food stamps or Medicaid we talked about earlier, you can entirely bypass filling out this complex financial statement. No joke. All you have to do is attach a copy of your official valid government benefits award letter right to your motion. You've also got to include the order form, which is WPF GR 340500. Now, listen closely, because the crucial point here is this. You only fill out the caption at the top with your case name and Section 1, which is the basis. You absolutely must leave Section 2, the findings, and Section 3, the order, entirely blank. The court will not fill out the order for you if you mess this up, but they are the ones who have to check the final boxes and actually sign it to make it official. So remember, do not fill in the judge's part. Finally, if you have to submit highly sensitive financial records, we're talking pay stubs, bank statements, or tax returns to prove your hardship, you really need to protect your privacy. You do this by attaching the Sealed Financial Source Documents cover sheet, also known as Form Seal FN. The absolutely critical step here is that you must write the word sealed exactly 1 inch from the top of the first page of every single attached document. This makes sure your private financial details are totally hidden from public view while still allowing the judge to actually review them. Section 4, Step-by-Step Application Process. Submitting your paperwork correctly. All right, let's walk through this chronologically so you feel completely prepared. Step 1. Make sure all those mandatory pattern forms we just went over are completed legibly. The courts require them to be either typed out or printed clearly in black ink. Step 2. Securely attach your government benefit letters or your sealed financial documents using that special cover sheet we talked about. Step 3. Take your complete fee waiver packet and present it to the court clerk at the exact same time, like concurrently, with your actual initial summons and complaint, or your petition. The clerk will take your fee waiver packet right then and forward it to a judicial officer for review. Now, depending on your county, you can usually do this in person, by mail, or sometimes even online. If you are in King County, for example, you can literally take your paperwork directly to the clerk's office at the Superior Court in Seattle or head down to the Regional Justice Center in Kent. Section 5. After submission and common mistakes. Troubleshooting the process. So, usually, the clerk forwards your application straight to a judge. In some district courts, it's actually highly recommended to call the clerk's office a week or so later just to proactively check if your application was approved. Now, let's talk about some common pitfalls. First off, if you do get your costs waived, you can't try to recover those costs yourself at the end of your case. But more importantly, if a justice court outright denies your fee waiver application, you're kind of out of luck. You cannot appeal that specific denial to a higher court. You'll just have to pay the fee to file your documents. However, if you are in a superior court, you actually do have options if a court commissioner denies your waiver. And honestly, this brilliantly illustrates the nuance of the court system. You basically have 2 primary remedies. First, there's a motion for revision. This is actually a constitutional right that allows you to appeal a commissioner's ruling directly to an elected superior court judge. Alternatively, you can file a motion for reconsideration. That's essentially asking that exact same court commissioner to take a second look and rethink their initial denial ruling. But understanding these steps and having the right forms, you can absolutely secure the financial relief that was designed specifically to protect your rights. So I want to leave you with this question. How will applying for this fee waiver empower you to finally seek the justice you deserve? Seriously, don't let upfront costs lock you out of the system. If you qualify, use this tool. Disclaimer, please note that this explainer provides general information and does not constitute legal advice. For specific cases, consult a legal professional or reach out to relevant Washington state resources.